Welcome. My name is Jeff Biller. I'm a professor of law here at the United States Air Force Academy and the deputy director of the Law, Technology, and Warfare Research Cell. And welcome to our first webinar on the topic of nuclear weapons and the law. This is the follow-on to an event held in November. It was hosted by the New York State Bar Association's International Law Section in conjunction with Litwork and a number of other fantastic organizations. I want to go ahead and throw a shout out to Charlie Moxley, who was the primary organizer for that event. It was a fantastic event. And if you're interested, if you just Google nuclear weapons and international law, a renewed imperative in light of the Russia-Ukraine conflict, you should be able to find a number of different sites that have a link to the videos from that, as well as the agenda and some other materials. So I highly recommend, if you haven't already had a chance to do so, to looking up those. But as mentioned, this is a follow-on event to that. And for this event, we are pleased to welcome Lieutenant Commander Chris Hart, United States Navy, for a discussion based upon an article he recently wrote in International Law Studies. The title of the article is Manifestly Unlawful: Why Russian Military Commanders Must Disobey a Nuclear Launch Order Against Ukraine. This article can be found on the International Law Studies website under volume 100. I have a copy right here, is what it looks like. It's a fantastic article. A little bit about Lieutenant Commander Hart. So this topic of legality related to nuclear launch orders is one he is ideally suited to discuss. He's currently on faculty at the Naval Academy's Leadership, Ethics, and Law Department, but he's also a submarine officer and has served multiple submarine tours, including as a department head on a ballistic missile submarine. We'll discuss Commander Hart's background a little bit more in just a minute, but up front, I have to provide the standard disclaimer that nothing that's discussed either by myself or Commander Hart in this webinar constitutes necessarily the opinion of our respective institutions, the Air Force Academy or the Naval Academy, or the Department of the Air Force or the Department of the Navy, or anybody else, frankly. I'd be surprised if anybody agrees on anything that we have to say in this webinar. Just kidding. As to any questions, as a general matter, please, as we go along, add questions into the Q&A function on the webinar. That's the easiest way for us to see and respond to those. For the most part, we'll probably leave most of the questions towards the end just to make sure we get through all the material. But if there's a question that's particularly relevant or pertinent at the time, then I can go ahead and respond to that during the webinar. So feel free to put those in throughout the course. So welcome, Lieutenant Commander Hart. And before we dig into the meat of your article, I was hoping that you could provide us a little bit more about your background, why you decided to write this particular article, where it came from, maybe a little bit about your history in the Navy and how that might have led you to be particularly interested in this subject.
Well, thanks, Professor Biller. I really appreciate you having me here, and I will second your endorsement of that fantastic symposium, which you all did a real public service by recording. And so if you haven't had a chance to watch it, I definitely recommend watching it on YouTube. So my background is as a normal submarine officer, not as a JAG. I'm not a lawyer. I am going to law school. I should be. I'm hoping to graduate in July. But I come at this problem initially from an operational standpoint, and I've thought about it from an operational standpoint for some time. Then, of course, what I do in the article is I try to apply a legal framework to this problem, which is it's a tough problem, but it's not unsolvable. So I graduated from the Naval Academy in 2009. Now I'm back here. I've been here for 3 years, and I'm lucky enough to teach fantastic students about laws of armed conflict and other to get to talk about this. So what drew me to this is, just like all of you, I'm sure we've all since February 2022 been quite horrified at the position we find ourselves in, where Russia, one of the world's top nuclear powers, potentially with more nuclear weapons than us, they've invaded Ukraine. We know this, but what's unique about this, at least since the end of World War II, is that we have a nation's armed forces that have been on high alert, specifically the Russians, since that invasion started. We've had Russian military commanders sitting there for 2 years now, thinking about whether or not today's the day they get the order that their president is openly threatening to give. And that's another unique thing about this conflict, is that the entire upper echelon of the Russian government has been threatening implicitly and explicitly, in some instances, to use nuclear weapons if necessary to avoid losing in Ukraine. So realizing that at this moment, in fact, there's Russian military officers sitting on watch who are the ones who are responsible for executing that order if it's given now. I imagine that they're thinking about some of these issues harder than they have in the past, harder than some of their predecessors have had to think about them. And so I wanted to go through and figure out, what is the legal framework? What should they think about as their legal obligations? There's plenty of moral and policy opinions and debates on this question, but to the extent I could find clarity on what the law says that's relevant to them, what is it? And what does it say? And what should they do?
Excuse me, I was muted. So with that background, what would you say the central thesis of your article was?
So as the title suggests, in fact, it states pretty clearly, after laying out the relevant legal framework, which I look at primarily, almost exclusively, the jus in bello legal framework that applies to the activities that are conducted by forces that are actually executing the conflict. When you apply that correct legal framework, it is clear that based on the facts in Ukraine, any launch against Ukraine of nuclear weapons would be illegal. And it's relevant, it should be relevant to those officers because, as our own DoD Law of War Manual says, but also is well established under international law, military officers under the law of war have a duty to disobey clearly illegal orders. Now, that's articulated in many places, but perhaps most relevant from a practical perspective for the Russian officers who are on watch right now is that that's the wording. Manifestly unlawful is the wording that's used in the Rome Statute when it talks about when an officer or a person being charged with a war crime can use the defense of superior orders. And the important thing, the legally important thing about executing an order that's manifestly unlawful is that you lose the affirmative defense of I was just following orders. That's never historically been a great defense, but it can work in some instances, but it does not work. And it's explicitly rejected by the Rome Statute when the order is manifestly unlawful. And so my conclusion is, because the law is clear enough that on these facts it's manifestly unlawful to launch, the Russian military commanders reading that order have a duty and a personal interest in not launching and disobeying the order.
Okay, good. Yeah. And in your paper, you start with the proposition that the legal question surrounding the use of nuclear weapons remains profoundly difficult. Certainly, we saw in the recent symposium, there are several areas that continue to be highly debated in terms of just how international law applies in the nuclear context. But my question is, for such a topic of such great importance, right? Clearly, one of the gravest threats to our planet, honestly, is the potential for nuclear warfare. And so for something that's so important, why do you think these questions remain as difficult, in many ways unsettled as they are?
There's a few reasons. One of the things that you encounter really rapidly, and you see this in the article, when you're talking about using these weapons, they're so unlike other weapons on many levels. For starters, just the order of magnitude of damage, even of the smaller weapons, of what I refer to as tactical nuclear weapons or low yield nuclear weapons, they're orders of magnitude more powerful than anything else we have. Additionally, unlike other weapons, they have these other elements to them. The radiation in particular adds this whole nother realm of uncertainty and forecasting potential harms. What will the geographic area of the harm be? What will the temporal nature of the harm be? How do you factor that in? I think it's harder to forecast with any degree of certainty what the actual harm will be. And it's also hard to factor all that into the legal analysis, because most of the precedent we have, the case law, the treaties, they aren't written with nuclear weapons in mind. And of course, really having grappled with some of those questions I just mentioned that are unique to nuclear weapons. So in some ways, it is difficult to figure out which law applies and how it applies. And of course, there's also the reality that there aren't treaties that say you can or you can't use nuclear weapons. And the ICJ, in the case that I spent a lot of time talking about, they mentioned that there's not a treaty that says specific to nuclear weapons, you can or you can't. Now, under international law, that means it's not prohibited. So you can, but you have to comply with the rest of international law. So the ICJ helpfully, in my opinion, lays out what the rest of that international law is and gives us a framework for solving this issue. But it's important to note that the ICJ, a bunch of very smart international lawyers, really, really struggled with this question. So it's not surprising that the rest of us also struggle quite a bit with it.
Yeah, and we'll get to that ICJ opinion and some of the legal analysis, but I want to go back to something you just said a moment ago, and that's kind of this notion that there are different types or classes of nuclear weapons. And I think that's important to talk about, because when we read a lot of, whether it be articles, the ICJ opinion itself, discussions of potential nuclear weapons use in Ukraine by Russia, oftentimes they talk about, well, in the case of tactical nuclear weapons is what's often raised, right? That might be the scenario of when nuclear weapons use might be legal. Is typically they fall back on that tactical, but I'm not sure that everybody quite has a proper understanding of the difference between a strategic and a tactical nuclear weapon, and just what that means in terms of their yield and other sorts of information. And this is something that's, I think, really helpful about your article as you do go through that. So perhaps you could discuss a little bit for us the different types of nuclear weapons and what that might mean for our legal analysis.
Yeah, absolutely. So the way I use tactical versus strategic nuclear weapons in the article, and the way it's often used colloquially anyway, that most people use it, they're talking about small nuclear weapons or big nuclear weapons. Now, when I say small, a Hiroshima-sized weapon today would be considered small, 15 kilotons. That would be generally, I think, pretty uncontroversially considered in the low yield area of these weapons. Now, obviously, it's extremely destructive, but it's considered tactical, and some of the history behind that is some of the early policymakers and government officials, and I think I quote Dwight Eisenhower in one of the footnotes, they looked at this as just a really powerful bomb, like the other bombs they had, just much, much more efficient. And they envisioned using it on the battlefield, just like the other bombs, but you just don't need as many of them. So when people are talking tactical, they're usually talking low yield, and they're usually envisioning some sort of battlefield application, like you can use that to blow a hole in the defenses, maybe dug in defenses, and it can help you push through an entrenched enemy. That would be a classic tactical application of nuclear weapons. Strategic weapons, on the other end of the spectrum, are much more powerful, and they're more powerful because they generally use a different type of nuclear reaction. The atomic weapons dropped in Hiroshima and Nagasaki, those were fission-based weapons. They split a nucleus, and that gives off some energy. Just a couple years later, in 1954, we had mastered thermonuclear weapons. Well, maybe master is not the right term, but we were exploding thermonuclear devices. And the reference point I'll give you is the March 1, 1954 Castle Bravo test, which was a thermonuclear weapon that was 15 megatons. That's 1,000 Hiroshimas. And that uses a different type of nuclear reaction called fusion, where you slam two nuclei together, and that releases way more energy than splitting a nucleus. So when you hear the term thermonuclear, that's generally what they're talking about, a fusion-based weapon. It takes a lot of energy to make that occur, which is where the thermo comes from. You generally need to produce a lot of heat, and it gives off a lot of heat. So it's far more powerful, orders of magnitude more powerful than the weapon used in Hiroshima. Now, those categorizations have been criticized because I think it's probably clear to everybody listening that if a low-yield 15 kiloton weapon were used anywhere on the battlefield in Ukraine today, you can imagine that it very well may have strategic impact. Strategic meaning affects the capacity of the adversary to fight, or the will of the adversary to fight. who knows how the Ukrainians would respond? Who knows how the world would respond? But it'd be a powerful message, a strategic message, frankly. And that's why people will criticize the strategic versus tactical distinction. I use tactical in my article to mean low yield, strategic to mean much, much higher yield.
Yeah. And I think that's really helpful, because I think a lot of people, when they think of tactical, they don't realize that the bombs dropped on Hiroshima and Nagasaki would be very, very, very small, even tactical weapons, right? That even those that are considered in the tactical category are much larger than anything that has ever been dropped in anger. So I think that that's helpful. And I think it's also, I like how you discuss it in terms of, it's not just about the yield, but it's also about the intent behind their use, right? And how they're categorized in terms of what they might be trying to accomplish. Okay, the next section of your paper kind of goes into a legal history related to nuclear weapons. And I wanted to cover one area. You mentioned numerous General Assembly resolutions from the UN related to the prohibition of nuclear weapons. And I just wanted to get your take on both the status or effect of those General Assembly resolutions, but also how they might influence our other legal analysis related to the question.
That's a good starting point, because there's plenty of General Assembly resolutions relating to nuclear weapons. It's important to remember that the General Assembly isn't capable of creating international law. It's not like a Congress for the entire world. They can certainly pass these resolutions. They don't have a binding legal effect. But what you see in the arguments that were made before the ICJ, and the court takes some of this on and grapples with it, is that perhaps with enough of these resolutions saying international law is this, international law says that, perhaps that's suggestive of an international perception that there really is a international law that exists, not because of the General Assembly resolution, but maybe it's observing what international law is. But the fact of the resolutions doesn't mean international law is what the General Assembly says it is. And the ICJ didn't treat it that way. And I don't think it would be appropriate to treat it that way. It's informative. It's one of the many things you look to as you try to figure out, okay, there's no treaty. Well, what does customary international law say? You can look at General Assembly resolutions, and many people do, but you need much more than General Assembly resolutions to say that something's customary international law.
Okay, good. Yeah. And so then we'll move on to what is probably our most important legal opinion related to nuclear weapons, the 1996 ICJ advisory opinion. First, it's kind of interesting. I think a lot of us who might spend a little bit more time on domestic than international law have our understanding of how cases might come in front of a court that's issuing legal opinions like that. How did this case come in front of the ICJ? Because the process is definitely different for the ICJ.
It is unique, and you wouldn't see this in U.S. courts. U.S. courts don't issue advisory opinions, and that's what this opinion is. So there was a movement, it's existed for some time, but in the early 90s, it really picked up some traction to try to use international judicial organs, in particular the International Court of Justice, to issue an opinion that would say that nuclear weapons were per se illegal. That was the motivation behind those who were really pushing for this opinion. And of course, that wasn't the US government, the Russian government. Neither of those governments wanted the ICJ to take this case, but there were many people who then and today thought on good faith, reasonable analysis that they've done, they've come to the conclusion, even though there's no treaty that specifically says it, international law is still developed to the point where any use of nuclear weapons would be illegal per se. You don't have to look at the facts. And so this campaign led to two requests to the ICJ to issue advisory opinions. The first one came from the World Health Organization that asked a very similar question to the one that ends up being addressed, which was effectively whether or not any use of nuclear weapons would violate international law, to include the World Health Organization Constitution. The ICJ ends up not taking that. They say they don't have jurisdiction there. That question from the World Health Organization is beyond the scope of their constitutional competence, the World Health Organization's competence. So the ICJ rejects that. They do not take that up from the World Health Organization. However, the UN Charter and the associated ICJ statute does allow the ICJ, in fact, it's very clearly and uncontroversially gives the ICJ jurisdiction to answer a question from the UN General Assembly that they pose on any legal issue. So the UN General Assembly does have the ability to ask for an advisory opinion on any legal issue. And that is the second route. That is the source of the question that ICJ ultimately answers. So the UN General Assembly passed a resolution, and they submitted this question to the ICJ on whether or not the use of nuclear weapons would ever be lawful under any circumstance. And the US and the Russian position was the ICJ has jurisdiction here. However, they also have discretion, and they should exercise that discretion because it's really a political question that they're not going to be able to help resolve, and they should use the discretion not to hear the case. Now, the ICJ heard the case, and they issued an opinion on the case, and that's the opinion that I reference in the majority of the article. Now,
okay, I think that's good. So Mr. Robach, who was one of the participants in our symposium back in November, has a question as to when it would ever be, or if it would ever be legal to use nuclear weapons, knowing how many lives it would take. And I think, so now it'd be good to hear what the ICJ had, and then maybe when we conclude near the end of the webinar, then I might ask you your personal opinion if you're willing to offer that. But what did the ICJ say on that specific question that you just raised?
So that was the key question. And the ICJ has been enormously criticized. In fact, many of the judges criticized the ICJ itself for not really answering the question asked, which is whether the use of these weapons could ever be lawful. And I'll read to you exactly what the critical finding was, which many have criticized as a non-finding. And this was a 7-7 vote with the president of the ICJ breaking the tie. And this is the wording that they used to answer the question. It follows from the above mentioned requirements, which we'll come to those shortly, that the threat of the use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict, and in particular, the principles and rules of humanitarian law. However, in view of the current state of international law and of the elements of fact at its disposal, the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self-defense, in which the very survival of a state would be at stake. So, to respond to the question of whether or not the use of these weapons could ever be lawful, that's asking, in a way, are they per se illegal? And the ICJ could not answer that question. Now, many of the judges did, and they, I think, all issued declarations or dissenting opinions or separate opinions. And we had many judges who came to the conclusion the weapons were per se illegal because of the effects that you can anticipate. But I would also point out that the ICJ opinion and many of the dissents, they really don't grapple with low yield weapons. There is a paragraph that mentions that low yield weapons have been suggested by the parties in front of the court, but they really haven't talked about them much. And so the analysis focuses very much on a large scale nuclear exchange and still doesn't reach a clear conclusion. So I think I won't go further than the ICJ did, which is to say it doesn't seem very clear in the current state of international law whether or not the use of nuclear weapons is ever lawful or unlawful. The position of the United States, which is very similar to Russia, which is very similar to what the ICJ said, is said in earlier holdings that we'll talk about in a second. The law of armed conflict or international humanitarian law governs the use of nuclear weapons and will only use them in extreme circumstances, to paraphrase. So the US and Russian position, as far as I understand them, is they're not prohibited, but of course they're governed by international humanitarian law. And that leads to the conclusion that in many instances, you can't use them, but there might be some. There might be some instances, and in fact, self-defense is the key thing that shows up when anybody suggests that they could be used. I've never seen anybody argue for the use of nuclear weapons outside of an extreme circumstance of self-defense scenario, to include, importantly, the Russian submission to the ICJ for this case. They reiterate over and over again that only self-defense could justify it, and these weapons are governed by international humanitarian law. So that's a long way of saying it's not clear under international law whether these weapons are per se banned.
Okay. Yeah, and so in your paper, you mentioned so that the court does say that they're governed by the UN Charter and by IHL. And there are many who said that this was a monumental holding. Why do you think even 1996, right? So nuclear weapons have been around for a long time. Why was just the very statement that the UN Charter applies and IHL applies? Why do you think that was considered monumental?
Several of the judges celebrated that. And I think it was judges who still thought that the court should have found they were per se illegal. They said, hey, at least the court went on the record and said, the law applies. And there's probably a few reasons for that. One is that there were arguments that were understood and had been made and were publicly made by respectable, reasonable scholars that because there's no treaty, because they're not mentioned in any treaty at all, because there's this perhaps a special type of weapon, whatever the reason was, the law just didn't apply. These were weapons outside the law. They're not mentioned in treaties, and to the extent treaties on international humanitarian law exist, they didn't think about nuclear weapons at that point, that's not a strongest argument to make. But Additional Protocol 1, which is a very, very important treaty, was in the whole negotiation of it, it was made very clear to the parties that this treaty is not going to apply new rules to nuclear weapons. So there was an argument that existed that nuclear weapons were not governed by law. And the ICJ came down unanimously to say that they are governed by law. They're governed by the UN Charter. They're governed by international humanitarian law. And frankly, that position, unanimous on the ICJ, was completely consistent with the US and Russian positions that they advocated before the court.
Yeah, and I think your point right there is really interesting, particularly with like AP1. And it's one thing to say that IHL applies, but entirely another, right, to say, well, exactly how does it apply? What were exactly the new rules that were suggested that AP1 might be, that might not be applicable to nuclear weapons? That, right, most of the states who had nuclear weapons explicitly said this treaty only applies to conventional weapons, not nuclear. What was the state of the rules and how does customary law? So given that somewhat tenuous relationship between really is our primary treaty governing IHL, Additional Protocol 1, the fact that so many states said that did not apply to nuclear weapons, how does that affect our analysis going forward? And we're going to get into your analysis as how you're doing that. To me, that's a very interesting question, in part because when we look at things like state manuals on IHL, like if you look at the UK manual, they tend to use language that's more vague when discussing nuclear weapons than they do when conventional. And it's hard to tell just how much that is intentional or how much of that is just hey, we're going to focus a lot more on conventional weapons because that's what's used much more often.
So Additional Protocol 1 is a fascinating document for many reasons when you are trying to apply the law of armed conflict to nuclear weapons. Now, Russia, it should be noted, has signed and ratified Additional Protocol 1. Unlike the United States, that's only signed it, we have not ratified it. So in some ways, applying Additional Protocol 1 to Russia, and Russian military officers are the nominal target of the article, it's easier. Their countries ratified Additional Protocol 1. Now, if we were to apply to the United States, we still end up, many have concluded that much of Additional Protocol 1, as much as even 2/3 of it, represents customary international law. And at least when you apply it to the United States, if you are doing something Additional Protocol 1 says, it's because it's customary international law, not because it's a treaty. Now with Russia, it's a treaty and it's in effect. But the twist about nuclear weapons is interesting. And I frankly don't think it's very well sorted out what exactly it means, because different people frame it differently. But what I've seen from across the board, to include nuclear weapon states, their allies, even the ICRC, there's an acknowledgement that at the convention for Additional Protocol 1, it was understood and it was reiterated in many ways that Additional Protocol 1 was going to capture a lot of customary international law. It was going to have a bunch of law from the Hague Regulations and Geneva Conventions. It's going to put it all into one spot, not all of it, but a lot of it. But there'd be some new rules too. and nuclear weapons were not going to be governed by those new rules. Now that argument assumes that the customary international law in AP1 does apply to nuclear weapons. And I haven't seen anything in any of the arguments that were put before the court or in the ICJ's opinion that would argue differently. The customary international law, in effect at that time, certainly applies to nuclear weapons as it would to any other weapon. But a new rule that AP1 adds wouldn't. Now, let me give you an example of why I think what that means is still a bit unclear. Reprisals. Reprisals were prohibited, mostly prohibited. There's a very narrow way to do reprisals under international law under AP1. The US position is that's new. That's new. That's not customary international law. Others take a different position, but let's assume in arguendo right now, that's a new rule. Well, if you take the position that new rules in AP1 don't apply to nuclear weapons and the prohibition against reprisals is new, then Russia can't do reprisals with any weapon. Unless it's a nuclear weapon, they can do reprisals. That seems like an illogical understanding of what all of those reservations and declarations meant. That seems like an illogical place to come out, but that's my personal opinion. I'm inclined to think what it means is that if there's a new rule that seems to per se prohibit these weapons, if there's a new rule that places special regulations on nuclear weapons, then that wouldn't apply. But to be clear, I frankly don't know exactly how to operationalize the new rule caveat for nuclear weapons in AP1, other than to say that any use that was criticized using AP1 would no doubt be defended by saying, well, that was a new rule in AP1. And people will debate what was a new rule and what was customary international law. I tried to avoid that in my article by avoiding AP1 as the basis for the law that I work through. The legal framework that I use is founded in customary international humanitarian law principles that everybody seems to agree on. So I do try to dodge that additional Protocol 1 ambiguity about how, well, whether new rules and what rules, frankly, apply to nuclear weapons.
Okay, that's great. And we're about halfway through the webinar, so I want to make sure that we spend plenty of time on that analysis. So let's go ahead and switch over to that structure that you lay out in the paper and that you draw heavily from the ICJ opinion on. And so I think the obvious place to start is perhaps distinction. So questions of distinction are frequently raised related to nuclear weapons. What is it about the effects of a nuclear weapon that challenge our understanding of distinction? So maybe you want to just briefly lay out that rule and then how it would be analyzed in the nuclear context.
So distinction is a requirement. It's a principle that exists under customary international humanitarian law. That I haven't found anybody that they disagree with it. And the ICJ said this was a cardinal intransgressible rule of international humanitarian law. It requires belligerents to distinguish between civilians, civilian objects, civilian population, and valid military objectives and combatants. So what that means is that you cannot aim at civilians. At a minimum, you can't intentionally aim at civilians. That's the more obvious iteration of it. It also requires taking action to make sure that you are aiming at a valid military objective. So it's not just avoid aiming at civilians. It's take positive action to aim at something you're allowed to aim at, which of course would prohibit just shooting blindly. For example, you have to be aiming at something that you're allowed to aim at. So a valid military objective would be something based on its nature, purpose, use, or location is making an effective contribution on the battlefield such that its partial or total destruction would be yield a definite military advantage. So, or a belligerent, a person who's fighting, either a combatant or an unprivileged belligerent, as you will. You can target military objectives. In fact, if you're shooting something, you need to be targeting a valid military objective or a combatant. And you definitely can't be targeting civilians, the civilian objects or civilian population. So you ask what makes that difficult? Well, there's another strand of distinction, which the ICJ talks about, and it groups indiscriminate attacks under the heading of distinction. And indiscriminate attacks, as I discussed in the article, they span distinction and another principle I talk about, which is proportionality. Those are all very closely related. But an indiscriminate attack would be one that isn't aimed at a valid military objective, or can't be directed at a valid military objective, or has effects that cannot be contained in a manner consistent with international humanitarian law obligations. So
Good. I'm glad you bring that up, because I think that's where a lot of people's frustration or questions lie is, hey, are these capable of being distinguished between civilian and military targets? One of our questions online, it's more of an ad bellum question, but I think it's relatable, discussing, hey, what about radiation effects that might leak out and affect a NATO country, for example, and what would be effect there? But I think it all gets wrapped up in this idea that, hey, can nuclear weapons, even tactical ones, be capable of distinction between military and civilian targets?
So looking at the wording of indiscriminate attacks, that last one, the effects of the weapons, it's indiscriminate if the effects of the weapons cannot be controlled in a manner consistent with the IHL obligations. Or if you use the text of Additional Protocol 1, which I wouldn't, I use customary IHL, it says you can't control the effects in a manner consistent with the protocol. So it's not that you have to be able to control every effect. You have to control it in a manner consistent with your obligations under international humanitarian law. So how do I understand that? I understand that to mean, well, you've got to look at the rest of international humanitarian law. Are you controlling the effects adequately to comply with IHL? And that very quickly leads to proportionality analysis. And I think that's the biggest one, although unnecessary suffering, as I talk about, is relevant here too. So let me jump over to proportionality analysis to answer your question. When we talk about the principle of proportionality, which is another principle of international humanitarian law that doesn't seem controversial at all, that's broadly accepted as a binding and relevant principle, it looks at whether or not the attack that is planned or is occurring can be foreseen to cause excessive civilian harm or civilian death, or a combination of civilian harm and death, to include to civilian objects, an excessive amount of civilian harm compared to the concrete and direct military advantage. So IHL permits some level of civilian death and civilian harm and destruction of civilian objects. And the level that is permitted goes up as the concrete and direct military advantage that will be gained by the attack goes up. So theoretically, if you drive up the concrete and direct military advantage high enough, you can have very, very high levels of civilian harm, and it can be lawful. So if you have very high levels of military advantage, then yes, you can have a lot of civilian harm, and it's not per se illegal. Now, I should note, there's debate on this question here, and I should talk about it briefly. There are some who argue, to include the ICRC and some who found this to be persuasive, that balancing test I just described, at some point, the civilian harm is so high that it doesn't matter how high the military advantage is. At some point, the civilian harm is capped. At some level, they might call extensive civilian harm. You can't justify extensive civilian harm. That's not reflected in the treaty language of Additional Protocol 1. I know that many very smart people have advocated that interpretation of effectively capping the civilian harm, regardless of the concrete and direct military advantage and how high that is. I don't find those positions persuasive, because I don't see the support for it in any of the state action, any of the treaties that exist on this topic, or any of the statements from relevant, especially affected countries.
Yeah, and that gets into another one of Mr. Robach's questions. He asked, when would it ever, or excuse me, not to mention the use of nuclear weapons could lead to escalation, global nuclear war, nuclear winter. And, this gets towards the proportionality question in terms of what do we need to account for, right? Are we just talking about the initial blast? Are we talking about long-term radiation effects? Are we talking about things that are perhaps foreseeable, but not necessarily probable, Given, right, what we've already talked about, one of the challenges being the level of effects and the different types of effects that occur from a nuclear weapon. How do we do that proportionality analysis, or can you even really adequately do it?
So I do think you can do proportionality analysis, and I do it in the article, and I avoid some of those things that you mentioned, and I'm conscious of it. I have actually a list of open issues here, and you've mentioned a few of them. So because when I run the analysis through all of these, I get just using a tactical nuclear weapon to the conclusion that without talking about escalation risk, without thinking about nuclear winter, without addressing environmental concerns, a launch against Ukraine would be illegal. Now, that just reiterates how clearly illegal any such launch would be. But if you change some of the facts, these other things might be more relevant. They might be necessary to grapple more than I did in this analysis to figure out, how do I factor this in? Now, there was a great discussion in the symposium about escalation risk. I know Professor Moxley advocated for factoring in escalation risk. And there's probably ways to do that. Although I think as soon as you start doing that, because the consequences of escalation are so high, even with a very low probability, it effectively overpowers the entire analysis, which I know many people have noted, and that's the whole point. So why would you launch nuclear weapons? But it's not clear to me that under international humanitarian law, a possible or maybe even probable response by the adversary, and then another response by your own side, that it's taken by other people after you target this thing that you're targeting, that I haven't seen in international humanitarian law that being factored into any other prosecutions of somebody for their proportionality assessment. I don't think there's a strong basis for it with the cases that have come before courts. I don't think there's a strong basis for it, because partially other weapons don't have this question, which is why I perhaps it ends up being relevant. But
Might be a good topic for a future webinar or panel.
I think so. I wrote this down as I would love more information on this. When I thought about this, I didn't factor it in because I didn't know how. And also I didn't need it to get to a clear answer. But I'm very conscious of escalation risk, and I don't know how to factor it in. And I don't know if IHL currently has space for it in the proportionality assessment. That seems at initial glance to be something that's too attenuated. Even if you're fairly confident there will be an escalation, it's not guaranteed and involves a lot of other people's actions. That's not really how IHL generally works. There's a target, you have a weapon, there's going to be some foreseeable harm with some probability from your strike, from your weapon, and that's what a reasonable military commander is expected to weigh, not what a lot of other people might do in response.
I'm actually working on a paper on that topic right now, so I'll let you know what I decide.
I can't wait.
Maybe we'll bring you back for a discussion. All right, so we are at 12:45, and I want to make sure we get to your case examples, because I think that's a really interesting part of the paper. I know that means we're skipping over the prohibition on unnecessary suffering, which should just mean that everybody out there should go read the article when we're done with the webinar here, so they can get into that. But let's go ahead and jump over, if you don't mind, to the current conflict between Russia and Ukraine. As you laid out well at the beginning, right? This isn't entirely theoretical, because many of the threats and actions that have been taken by Putin in this situation. So you lay out several different scenarios and analyze each one. What were those scenarios? And then let's maybe just go through what you think are the most important or relevant of those.
Okay, so I, of course, have no idea what the Russians are thinking about targeting Ukraine, and I have no access to that information. I don't know if anybody knows that, but I did try to take some representative samples and extrapolate based on my analysis there. So the first example that I picked was following Defense Minister Shoigu's threat to hit decision centers. Well, I looked at a key decision center, which I found to be the Ukrainian Ministry of Defense, located in the center of Kyiv. And then I walked through applying IHL to a strike on that target. And then I also looked at, and this is more of a thought experiment applied to Ukraine, which is a submarine in the middle of the Black Sea that's imminently threatening to launch nuclear weapons, which Ukraine doesn't have submarines and they don't have nuclear weapons. But that's a common thought experiment. And I wanted to run through it on the facts as they would present in this conflict, because when you do, you realize that is outside of a vacuum, that's a much harder thing to justify.
Yeah. And there's a lot
And
of relations between, the idea that, hey, you could use a nuclear weapon against a fielded force in the middle of some plane where there's almost no human beings other than the military forces there. That's a common kind of thought experiment related to that. Because it is very, and given that you're a submarine officer, might have some particular expertise there.
yeah, you broke up a little bit there. Were you asking me to dive into the submarine example?
Yeah, let's go ahead and start with that one. Sorry about that.
No, that's all right. So the vice president of the ICJ, Schwebel, at the time that this opinion was issued, he had this dissenting opinion where he said, look, nuclear weapons might possibly in some scenarios be lawful. And here's this example. Think of a submarine that's getting ready to launch nuclear weapons in the middle of the ocean, and the other country hits it with a nuclear depth charge. That might be lawful. And so I wanted to explore that a little bit. And I ran it through my tests of distinction, proportionality, unnecessary suffering, and it very easily passes the unnecessary suffering test, which just very briefly is you under unnecessary suffering, you aren't allowed to have superfluous injury beyond that which is justified by some sort of military advantage. So very similar to proportionality, but it's talking about the combatants. So the harm suffered by submariners would be completely consistent, in my assessment, with harm suffered by a torpedo that happens to find the submarine, or a normal depth charge. The fact that it's nuclear, I don't think would have any impact on their manner of death. So I don't think there's an unnecessary suffering issue raised there. But in Vice President Schwebel's assessment, he doesn't say what ocean the submarine is in. I imagine he thought he put it in the middle of the Atlantic or Pacific or somewhere very, very far from land. But if the Russians were to do this in the middle of Black Sea, for example, right in the middle of it, they wouldn't be any further than 100 nautical miles from a country in any given direction. And of course, if they did this, it would probably be much closer than that. So I looked at the Castle-Baker test that was run in 1946 to get a sense of what a nuclear depth charge does. And that test was run by the United States in the Bikini Atoll, and it used a 23 kiloton weapon, so a low-yield tactical nuclear weapon by our standards today, and it detonated it at a depth of 90 feet in a lagoon. And it destroyed all of the ships within 1,000 yards. Beyond 1,000 yards, ships actually, most of them were not destroyed. Relevant to proportionality and distinction is that several hours later, U.S. aircraft detected plumes of highly radioactive material 80 nautical miles away. So from a distinction and proportionality assessment, it's legally fine that the submarine was destroyed, but that plume of highly radioactive material in the Black Sea, 80 miles away, that's we're heading to another country, and presumably we'll get more than 80 nautical miles. It'll make the full 100 nautical miles. And now we have radioactive fallout in another country, not even necessarily Ukraine, or could be Russia, or any other country, potentially NATO countries bordering the Black Sea. And civilians, we know now, are harmed very substantially by radiation. So you'd have to factor that civilian harm in. Is that justified? Certainly Ukraine not having any nuclear weapons, I don't think you get anywhere close to the point where you can justify that. If you were to change that and they have nuclear weapons, then maybe your analysis changes, your conclusion changes. But those aren't the facts now. Ukraine doesn't have nuclear weapons. So I don't think you can use a nuclear depth charge in the middle of the Black Sea and have it be lawful right now, because I don't think there's a high enough military advantage, concrete and direct military advantage, to justify the civilian harm that will occur from the radioactive fallout, which will inevitably reach the shore. So that's
yeah. And let's, in the time we have remaining, I would like to address your discussion of a tactical strike on a city, partly because you rely somewhat on the Shimoda opinion, which is something I don't think a lot of people are familiar. A lot of people are familiar with the ICJ opinion, but not so much with the Shimoda opinion. So why don't you discuss that strike, but maybe remind us what that opinion is about and why it's important.
Great. Yeah, there's two court cases on nuclear weapons that I've been able to find, and many commentators have agreed. There's only two. We've talked about the ICJ case. The Shimoda case was a case filed in Tokyo District Court. It was decided in 1963 by survivors of the Hiroshima and Nagasaki bombings. And they were suing the government of Japan. They were suing the government of Japan because in its peace treaty with the United States, it effectively immunized the United States from civil claims relating to its conduct of the war. And so these survivors said they were very severely harmed by an illegal strike. And so the court had to answer the question, what was the strike, or were the strikes on Hiroshima and Nagasaki lawful? And that court looked at the law as it existed in 1945 and concluded that those strikes were unlawful. They were indiscriminate attacks that caused unnecessary suffering. Now, that's a Tokyo District Court. It's not binding on any other court, but I can't imagine that if these weapons are actually used, a reviewing court will not be aware of it, will not consider the fact that, hey, at least the one court that's looked at the use of nuclear weapons on the battlefield concluded they were unlawful. So take that for what it's worth. I find it to be persuasive. Now, I also talk about, okay, a strike in Ukraine on in this case, Kyiv is the example I use because there's a valid military objective in the middle of Kyiv. You can pass the distinction test by aiming at the Ukrainian Ministry of Defense. And well, you pass part of it. You pass the aim point test. What am I aiming at? Okay, you can aim at that. But then you run into issues with, is this indiscriminate? Are you controlling the effects consistent with your obligations under IHL? Well, what do you know will happen if you use even a low yield, a 15 kiloton weapon in the middle of a city? Well, the only data points we have are Hiroshima and Nagasaki. And so in the article, I reference a lot of what those witnesses talked about. And it's worth just mentioning the things that you have to factor in when you think about civilian harm and, frankly, unnecessary suffering to those combatants who are there. You can expect, just like in Hiroshima, we had 70 to 80,000 killed immediately, 150,000 killed by the end of the year. Those who died afterwards died pretty painfully, generally of severe hemorrhaging. They had severe infections as a result of radiation exposure. You can also expect, in Hiroshima, they had something like 70,000 civilian houses were destroyed, 5 square miles completely incinerated, and many miles beyond that damaged in some way. Now, today, you'd have some other challenges too. For example, we know today about electromagnetic pulses, or at least it's been mentioned in some studies. Electromagnetic pulses, briefly, something that might make it very difficult to use any electronics at all for some period of time, depending on a ton of variables. And we don't fully understand it very well. But I doubt that there are very many electronics being used in Hiroshima. But in a city today, that's going to matter a lot more. There's a lot of reliance on electronics. And what happens when in the remaining surviving part of the city, all electronics are off for some period of time? It's going to severely complicate the response, in addition to the people already being, frankly, hysterical and many of them very physiologically impacted by the radioactive fallout that they're experiencing. So to the extent that you can wrap your hands around it, you can expect several 100,000 civilians to be killed by strike in the middle of the city. So you'd have to ask, what sort of concrete and direct military advantage could justify that? And it's very difficult to think what would, short of where the ICJ stopped doing it, reaching conclusions, which is an extreme circumstance of self-defense such that the survival of state is in question. And it's very important in my analysis that there's no question of the survival of the Russian state in the present facts. So I don't reach how to analyze that if there is a survival of state question. But I should also note, while we're talking about survival of state, this is another important open question, in my opinion. The ICJ throws that out there, and that term is thrown out frequently to say, well, maybe in a survival of state scenario. But there's not clarity on what that means. So if you were to apply that to Russia, I don't think we're anywhere close to it. But from the Russian perspective, would the Russian president, the survival of the Russian president, be survival of state? In that case, maybe would it justify the use of weapons? I don't think so. I don't think that's what it means. What about the survival of the capital, though? When Wagner was marching on Moscow, they seized Moscow. Would that be survival of state? Is it the survival of the government? a regional capital or whole region of Russia, what is survival of state? Because that categorization seems to be very important in figuring out when the use of nuclear weapons might be lawful. And it seems like an obvious answer until you really start thinking hard about scenarios that might justify the level of harm we're talking about. Keeping in mind, everything I've said in this discussion has been talking about tactical low-yield nuclear weapons. We know that thermonuclear weapons are thousands of times more powerful than that.
Right. All right, we are just a few minutes from an hour, so I want to make sure that I leave some time for anybody who might have a question here. So I'm going to go look over our list. We did, and again, I think this gets to kind of the unusual nature of an advisory opinion. What is the binding effect of an ICJ advisory opinion? Right, obviously there aren't specific parties in front of the court, but it's also obviously referencing nuclear weapon states in terms of its decision.
So the ICJ, by virtue of issuing the advisory opinion, hasn't legally bound the United States, hasn't legally bound Russia, hasn't legally bound anybody. However, I think it is persuasive because, well, Russia and the United States frankly agree with the conclusions. There's not really daylight. There's not any discernible daylight between the ICJ's conclusion that the law of armed conflict, international humanitarian law, customary principles apply, and distinction, proportionality, and unnecessary suffering would have to be applied to figure out if the use of these weapons was lawful. That's really consistent with the major nuclear powers' position on this issue. So that, I think, is helpful. That helps lend persuasiveness, for me anyway, to what the court said, in addition to being well-reasoned and having many dissents and declarations that amplified on some of the reasoning. But it's persuasive. It's not binding.
Okay, and we also have a question here, interesting. Does your analysis translate to the Israel-Palestine conflict? And here I think the idea is Israel is presumed to be a nuclear weapon state. Gaza Strip, I'm assuming they're specifically speaking of here, clearly does not have nuclear weapons. Therefore, would any sort of analysis that you apply to Russia, Ukraine have some carryover to potential use of nuclear weapons in the Israel-Gaza conflict?
So the legal framework that I talked about is not unique to nuclear weapons. It's not unique to Russia thinking about nuclear weapons. It's not unique to Ukraine. So certainly the legal framework is very much relevant. These are binding customary international humanitarian law principles that apply in all armed conflicts everywhere. So they certainly apply in Israel and in its fight against Hamas.
Okay, great. And then we'll take this as our last question then, because we're about out of time. What impact will the treaty prohibiting nuclear weapons have on the future development of law in this area?
It's really fascinating. So when the 1996 opinion came out, there was no treaty at all that existed that specifically addressed the use of nuclear weapons. Well, today there is a treaty that specifically addresses the use of nuclear weapons. It's the Treaty on the Prohibition of Nuclear Weapons. And we have to remember when we talk about treaties that they only bind the states that are parties to the treaty. So at least in the short and medium term, without a nuclear powered state joining the treaty, those states are not bound by the treaty. The only way it could eventually bind nuclear states is not because it's a treaty, but because along with many, many other things and lots of other state action and who knows how long, you take a look at customary international law, and it's a data point that suggests customary international law has moved in some way. But without a nuclear powered state joining the treaty certainly doesn't bind a nuclear powered state. Does it lend weight to that stack of things you're using in your customary international law argument? Yes. Does it change the conclusion? I don't think that changes the conclusion now, and I think it would need more than just the treaty. But I am aware of quite a few initiatives that many people are pursuing to build that pile of customary international law data points to make this argument again. And I think some people are even trying to bring this in front of the court again to take another look at it. So perhaps we'll get an answer at some point.
Who knows? Well, I want to thank you very much. I enjoyed the conversation. I hope everybody else did. There's a lot to cover there, I know. And so there's things that we didn't get to. I hope what that does is pique your interest to go download his article and read it. I hope it also piques your interest to just engage in further discussions like this that we'll have in the future. But I want to give my thanks to Commander Hart for his joining us here. I hope he's able to join us again in the future. Any concluding thoughts before we go?
Yeah, I very much appreciate the opportunity to come here and speak, and I appreciate the questions. I hope we can keep the discussion going. And I just wanted to end with my major takeaway from the whole article, and the point I've tried to make here today is that military leaders have a legal obligation to disobey clearly legal orders. And the use of nuclear weapons is governed by the law. And we know that from the ICJ opinion and what nuclear-powered states have said. And specifically, that's the UN Charter and Jus ad Bellum, and my focus of Jus in Bello, international humanitarian law. And out of that, while some debate which portions of it are relevant to nuclear weapons, nobody seems to debate that distinction, proportionality, unnecessary suffering are relevant. And when you apply those principles to the facts of Ukraine, you reach the conclusion that any use of nuclear weapons in Ukraine with these facts would be clearly illegal, and therefore Russian military officers should disobey a nuclear launch order against Ukraine.
Great, and I appreciate you bringing it back to that baseline. All right, well, thank you everybody for joining us. Hopefully we'll have another on this series on nuclear weapons coming up in February. Well, you should see advertisements wherever you got the link for this particular one out there as well. And also look for our webinars on the topics of cyber and space. I know we have several of those coming up in the next couple of months as well. I hope you all have a wonderful day. And again, my thanks to Commander Hart.